Well, good afternoon, and thanks for joining us. My name is Vince Farhat, and I'm a clinical professor at LMU Loyola Law School and a member of the Beverly Hills Bar Foundation Board of Directors. A criminal defendant has important trial rights, including the right to remain silent, the right to consult with counsel. But what happens when a defendant takes the witness stand in their own defense? Their status shifts. They don't shed their rights as a criminal defendant, but they do assume some of the burdens of a testifying witness. During today's program, we're going to navigate the tension between the defendant's right to advice of counsel without judicial interference and the defendant's burden as a testifying witness to offer sworn testimony uninfluenced by a lawyer's midstream tinkering. The right forms the heart of the Sixth Amendment right to counsel, and the burden serves as the central truth-seeking function of the trial. And Jose, if you could move to the next slide. Just to get a few housekeeping things out of the way, your CLA certificate will be sent right after we finish this program. Please take a moment to complete the survey. If any issues come up, please log into bhba.org and please sign up to watch other programs. We have really outstanding programming across a whole different group of practice fields. And during this program, you'll also have the opportunity to pose questions to our panelists. Next slide, please. What we're going to do today is we're going to provide a case overview. I'll give a quick case brief on really the case that's guiding this conversation today, Villarreal versus Texas, which is a case that was decided by the Supreme Court in February. Then we'll have our panel discussion with our rockstar panelists to talk about the implications of the case, defendant testimony and cross-examination, and their lessons learned from, probably between the two of them, they've had 30 or 40 criminal trials. As I mentioned, you'll be able to ask questions throughout by posting them, and we'll also have time at the end for Q&A. Next slide, please. So who are our speakers? We're very fortunate to have Cassie Palmer and Michael Freedman speaking today. Cassie is a partner at Kendall, Brill, and Kelly, and a former senior federal prosecutor with more than 15 years of litigation experience. She served over a decade in the U.S. Attorney's Office for the Central District of California, leading the public corruption and civil rights section. Cassie was the co-lead counsel in a really famous LA City Hall corruption investigation that produced more than 10 convictions. She was named the LA County Bar Association's 2025 Prosecutor of the Year. She clerked for the Honorable Arthur Alarcon of the Ninth Circuit. She earned her JD, magna cum laude, from Loyola Law School, where she served as chief articles editor of the Loyola of Los Angeles Law Review, and her BA summa cum laude from the University of Utah. That is Cassie. Michael is the managing partner and founder of the Freedman Firm. I believe, Michael, you've had your 5-year anniversary of the firm. Is that right?
5 years.
5 years. And has grown his practice immensely in these years. A former federal prosecutor, he represents individuals and companies in criminal defense, regulatory matters, and high-stakes civil litigation nationwide. He's tried 18 cases to verdict. He's been named one of the top white-collar lawyers and top 100 lawyers in California by the Daily Journal. He serves on the boards of the Federal Bar Association and the Beverly Hills Bar Association, and he, in fact, chairs our criminal law section, which is presenting this program this afternoon. He also clerked for the Ninth Circuit for the Honorable Johnny B. Rawlinson. He earned his JD from University of California College of the Law in San Francisco. He has a master's degree from Harvard and has his BA from the University of California, San Diego. So many thanks to Cassie and Michael for joining us today. So before the case of Villarreal, the Supreme Court held in a case called Genders v. United States, that a trial court may not prevent a testifying defendant from conferring with their lawyer during an overnight recess. The court had also previously held in a case called Perry v. Leak that a trial court may prevent a testifying defendant from conferring with their lawyer during a brief daytime recess. So both of these cases, which are in your program materials, imposed unqualified bans that separated clients from their counsel entirely. This case, Villarreal, presented a third scenario. There was an overnight recess that interrupted a defendant's testimony, but where the court allowed counsel to speak with his client while limiting the content of the discussion. This was a qualified conferral order as opposed to the unqualified bans in Genders versus Perry. What were the brief facts of this case? Next slide, please. Defendant Asa Villarreal was charged with murder in Bexar County. He elected to take the stand, and during the trial, he was testifying. He was in the middle of his direct examination when the court adjourned for an overnight recess. So the judge instructed the attorneys not to confer with their client regarding his ongoing testimony, but permitted them to discuss other trial matters. What's interesting, and I'll read you the comments or the statements that the court made. To defense counsel, the judge said, quote, "Ask yourselves before you talk to Villarreal about something, is this something that manages his testimony in front of the jury?" He also addressed the defendant. He said, quote, "I'm not telling you you can't talk to them. You have a constitutional right to confer with your attorneys about certain topics, such as possible sentencing issues." Defense counsel objected that the no conferral order was a violation of Villarreal's Sixth Amendment right to effective assistance of counsel. Next day, he went back on the stand, resumed his testimony. There were no further objections about the limitation at that point. He was convicted. He was sentenced to 60 years in prison, and the issue went on appeal. On appeal, the Texas Court of Criminal Appeals held that the qualified no conferral order was a permissible exercise of the trial court's discretion. It went to the Supreme Court. Next slide, please. The specific issue was whether a trial judge can instruct defense counsel using the court's words, quote, "not to manage defendant's testimony" when he was a witness at his own trial and the testimony was interrupted by a 24-hour overnight recess. Ultimately, what the court held was that a qualified conferral order that prohibits discussion of the testimony for its own sake during a mid-overnight recess does permissively balance the defendant's Sixth Amendment right to counsel against the burden of offering unaltered trial testimony, and that doesn't violate the Constitution. What was the court's reasoning? Next slide, please. As I mentioned, there are these two prior cases, Genders and Perry, both of which in your materials, that addressed different situations. In this case, Villarreal really sort of addressed this third situation. The court reasoned that obviously it's a fundamental criminal defendant's right to consult with counsel, but acknowledged, based on the court's precedent, that when a defendant takes the witness stand, they assume the position of a witness, which includes these burdens, including not receiving advice from counsel that could influence their testimony in light of the testimony already given. There's a lot of discussion in the Villarreal decision about Genders and Perry, and I'd recommend that people read those cases because it really teases out this sort of the dueling burdens and responsibilities and rights. Ultimately, the court found that a testifying defendant and defense counsel may not discuss the client's ongoing trial testimony during an overnight recess, but can discuss trial strategy. Interestingly enough, the court noted that a defense attorney can rehearse a client's testimony before the client takes a stand, can debrief that testimony after the client leaves the stand. But the court noted that while the defendant is sworn in as a witness, consultation about the testimony itself, rather than just incidental discussion, that's the words of the court, incidental discussion of testimony in service of other protected topics, sheds its constitutional protection. It's noted that in this decision, the Supreme Court cited an ABA ethics opinion, which is an ethics opinion that was published that gives guidance to attorneys on really the do's and don'ts of witness preparation. That ABA opinion is in your materials, and we do recommend you take a look at that. Next slide, please. The lineup, the court was unanimous in affirming the lower court, but there was a divergence of views, not surprisingly. The Justice Jackson wrote the majority opinion, joined by the Chief, and Sotomayor, Kagan, Kavanaugh, and Justice Barrett. There was a concurrence by Justice Thomas and a concurrence by Justice Alito. Justice Thomas took an interesting approach. His position was, and it was joined by Justice Gorsuch, that really the court didn't need to didn't need to really publish on what he called a hypothetical situation. He argued that it needlessly expanded their precedents. The majority responded by saying, look, it's true that Perry never stated the rule that they've drawn, but if it did, they would have had no need to take the case. And the majority's view was that their result followed neatly from their precedents. Justice Alito took an interesting approach. He wrote to set out a framework under which courts should analyze limitations on communications between a defendant and his attorney. He went so far to sort of comment on if there's an overnight break in the proceedings, the attorney must not improperly coach his client. He said, for example, an attorney could say, let's discuss what plea terms you'd be willing to agree to. But he couldn't say, the counsel couldn't say, we will really need to secure a deal unless you clean up mistakes A, B, and C that you made today on the stand. So it's very interesting. Alito's concurrence tried to give some guidance, but he was really writing for one. Next slide, please. So the decision has received a lot of coverage in the legal press. It raises some interesting issues. How do we, as practitioners, comply with the decision? Will the courts, did this phrase incidental discussion generate disputes? So let's turn to the speakers. And Jose, let's actually take down the, there we go, so we can see our speakers. So let's talk first about the implications. So thoughts on the opinions, thoughts on the concurrence. Cassie, I'll start with you.
Sure. I think certainly we're going to see a lot of cases discussing, maybe it was very clear to the justices about what this means in terms of what is an incidental discussion. I think as practitioners, that's not going to be so clear to us. And so, especially because Alito was writing for one, he gives some helpful examples, but are lawyers bound by that, right? And so I think that one of the most important things for practitioners to do if they're facing this type of bar, which of course the court could do sua sponte, or prosecutors may increasingly be asking for this, just as they ask, for example, to sequester witnesses, is making sure that they know exactly what the court in front of them is talking about, and kind of teasing out some of these scenarios with the court so that you have a very good record. And if it goes beyond the fact in Villarreal, then certainly that's something that can be challenged, right? And so, it is difficult because when you're talking about strategy, for example, which everyone says is permissible, when you say, listen, your testimony is hurting us, let's discuss a plea. Of course, as we were discussing, many times, your client's going to say, what does that mean? How is it hurting it? And you sort of have to say, I guess we can't talk about that. I can't tell you that. But I do think it's difficult. The one other aspect I think, and I think we're going to get into this, is sort of there's this substantive discussion of, here are the topics you discussed. Let me remind you of this and that. And that's very substantive. But what about something like, hey, you are pausing a lot. Like, you don't need to pause a lot. That, to me, doesn't actually implicate the truth-seeking function. But according to what the court said, arguably that falls under managing testimony. So we're not just talking about substantive things that I think clearly fall under this truth-seeking function, but also things like everyone gets nervous when speaking, and particularly in front of a jury, it can be very scary. And certain behaviors might come out that actually have nothing to do with true credibility. They can be saying exactly the truthful testimony, that it's truthful, but they have some kind of tick or something like that. Is that completely off of the table? It seems like it probably is. And that's a distinction, I think, under the ethical rules, lawyers would sort of separate those out previously and thought, okay, I can't talk about substantive things or coach on that. But certainly it's fair game to talk about, hey, you're pausing for 10 seconds when they're asking you a question. Just trust yourself. You know what the truth is. Just answer more easily.
Good point. Michael, your reaction to that, what do you think?
Yeah, I think from a practical point of view, the missing piece of this whole discussion from the court is like the client in all of this, the defendant, because I think anyone who's ever had a client on the stand, can remember the reality. They come off the stand and you go to a break and the first thing they're going to say is, well, how am I doing? And you can say, fine. We were talking about earlier, it's an interesting question whether this really changes anything, assuming you're already following the ethical rules, right? Because if you respond to your client by saying, well, just keep telling the truth, that during this temporal phase that the court is looking at could now be seen as managing the testimony, even though it's exactly what you'd be expected to say anyway. And to Cassie's point, like, even if you don't say it that way, but if you go home over the evening and you think it's going terribly and you talk to your client, I think we should reconsider that plea. they're going to obviously say to you, well, is it because of something I said today? The other thing I don't think anyone has grappled with, and I'm sure is going to come up for practitioners, is the attorney-client privilege dynamic of all of this. Because with any other witness, there's no privilege. So anyone who's even been in a deposition, the first question after a break is, well, have you talked to anyone else? And if the answer is, yeah, well, I talked to opposing counsel in the hallway, fine, you can inquire, what did he say? But in this situation, if the defendant is back on the stand and the prosecutor says, well, did you talk to anyone at the break? Yes. Who? My attorney. What did he say? Objection privileged. And even if the court says, well, counsel, I need you to tell me what you said, I think the only thing a defense lawyer could say is, well, Your Honor, I assure the court that I'm aware of and followed all my ethical duties. So it's a little bit of a hard to imagine hypothetical how a violation of this would play out, which sort of brings me back to the first point, which is for practitioners, as always, following the ethical standards is key. And I'm not sure that distinction is affected by this opinion in practical terms.
And it does make you wonder, was this opinion really, really necessary, where counsel understands that they have an obligation to ensure the truthful testimony?
Can I add one more point? I do think where the appeal might have been necessary is if the lawyer is, let's say, like overly zealous about the ethical rules and in some way is therefore limited in advising the client in a way that the client could be prejudiced, and that gets into sort of the slippery slope between managing the testimony versus advising on the case. You have to be able to advise on the case. So to the extent that's what this opinion is saying, fine. That seems paramount.
One other point I think I would add is that the court did say that there was nothing in the record reflecting what the attorney wanted to discuss with their client that they weren't able to, which I think to Michael's point also is difficult because you're going to tell the court and in front of the prosecutors, I wanted to talk to them about XYZ and I wasn't able to. So there is this tension between making the record and the attorney-client privilege. And it seemed like the court thought it was important that there was no record of what they would have talked about and were unable to. And so I think it's important to make a record, but it can be very difficult. I think maybe at a high level, you could discuss larger areas that you wanted to discuss and were unable to. But I do think that there is an inherent tension there with privilege.
And I might be getting ahead of us a tiny bit, Vince. I apologize.
Oh, keep going.
I know we're going to get into more practical tips. And one of the things we're going to talk about is one of those award-winning trials that you mentioned, Cassie having. I represented the defendant. And
you guys are on opposite sides, huh?
We were.
And you're still friends.
We're still here today. But so when as Cassie will remember in that case, and in many where you're the prosecutor, if you do have to talk to a witness, over the break, whether they're testifying or not, you don't represent them. So it's not privileged and you have the same disclosure obligations as always, and you have to do the right thing. So in that trial, I'm remembering a certain example where something came up that caused the government to go back to one of its witnesses, and they did it in the proper way, which is with an agent, and they had notes. And then they emailed us, in the middle of trial. We went and spoke to this witness to clarify some things, and here are the notes, and, implied in that is have added on cross-examination. But, and this is hypothetical, didn't happen in that trial, but what if the defendant is testifying and there's some, aside from just a cosmetic suggestion that you need to get through to the client, stop grimacing every time they ask you about this. But what if some real substantive issue comes up about some documents and you really do feel duty bound to help prepare the client over the long break? You can't let the prosecution know that. You can't say, oh, here's some notes of my meeting with my client where we went over these documents. So in a certain way, you're almost more hamstrung or limited on the defense side by the privilege considerations, because you can't even undertake that sort of mid-testimony discussion that the prosecution, as long as they follow all their other obligations, has a little bit more leeway on.
Yeah, I would assume that one of the things I was thinking of is that from the prosecution perspective, when you're asking for this kind of bar, the judge may make it reciprocal And most good judges would, and I think most good defense attorneys would say, okay, so you're asking for this bar, it should be for everyone, just like witness sequestration is. And so you're going to be stuck with that same kind of procedure, most likely. And then I think you are going to be in a situation where, for example, I have had, when I was a prosecutor, I did have situations where I thought that a witness on the stand inadvertently gave false testimony. Okay. So if it's in the middle of their testimony and it's something that we have the ethical duty to correct with the court, I think then you're in a situation where you have to let the court know about that. And I think probably from the defense side, if there's something you really needed to ask, maybe that's something you can go in camera because it implicates like privilege and, you know, whatever, potentially, but then it might be something you don't want the court to know. So it's quite difficult, I think. Well,
as a practical matter, when a prosecutor faces that situation and needs to make some sort of disclosure, how do you do that mechanically? I mean, you're in the middle of trial. How do you deal with that mechanically?
Yeah. So usually, so in one of the instances, it was happening live as I was examining the witness, and I knew that she said something that not only was false, but it was also problematic because it implicated the defendant asking for an attorney, which wasn't true. He never did that. And so it was very complicated. And I asked the judge for a sidebar, and the judge was angry because he thought this was actually truthful information that I had improperly elicited. And so he said, no
good deed goes unpunished.
Yeah. And so he said, no sidebar repeatedly. And I had to wait for a break and then explain all of the situation, and then talked with the attorneys about the best way to do that, because one of the concerns there was that they did not want to draw more attention to that. And so the judge just read a very generic stipulation that said like that didn't happen, instead of going back with the witness. And she was confused and just was mixing it up with another case. In another instance, it was overnight. And so that's when we went over, we talked to the witness, and then we gave everything over to the defense and kind of let it happen that way and talked to them about like the best course to correct that testimony. So it can be by stipulation, or it can be additional testimony where you're correcting it.
To add a wrinkle to that, though, you know, oftentimes the government witnesses in criminal trials are themselves defendants who are cooperating. And so they have lawyers. And so I'm thinking next week I have a client who's testifying in a criminal case. I'm representing him in his own criminal case. And so the government can't meet with him to prepare for trial without his lawyer because he's a represented party, but I'm not involved in the case in which he's testifying. So when the government's meeting with the cooperator in those situations, there's a third lawyer in the room who has the attorney-client privilege with the person testifying, but isn't actually isn't actually involved in the new case where the person's testifying. So that's always and oftentimes that lawyer will talk both with the government and defense counsel. And so that just sort of adds a wrinkle. This opinion doesn't really address if a defendant is testifying in not his own trial, what is the role that his own lawyer can have? Because usually you're just sitting there in the courtroom during the testimony itself, but for the prep, it's a whole different story.
So let me ask then, so Villarreal, let's talk about how the decision can impact how we prepare defendants, clients for their testimony. Like now we know this case is out there, whether somebody asked for a no control order or not. How does it affect, if at all, how you would prep your client? And you realize, okay, my client's going to testify, and they've made that decision. You have to prep them as defense counsel.
Michael, why don't you start and then I'll fill in.
Yeah, I mean, I think one of the other interesting parts of this whole area is how rare it is for defendants to actually testify in their own case. In my last trial last year, my client did testify, and it was the first time I've done that as a defense lawyer over numerous trials. And I think Cassie would agree, it's of all the like many skills you develop as a federal prosecutor, like one of the hardest ones to do is cross-examination, because oftentimes the defense doesn't put on a case. And even if they do, it's often like a paralegal or an expert, something a little bit more routine. And so when a criminal defendant decides to testify, it's a big event in the case. And it's something that a defense lawyer is thinking about from the beginning, because it's ultimately the client's right to testify or not testify. And when the government rests and the defense has an opportunity to put on the case, most judges will make a record of inquiring directly with the defendant, making sure he or she understands those rights, and either decision is his or her own. But the attorney is obviously weighing in throughout. And so, and it obviously from a practical perspective too, it changes the course of the trial, right? If you're defending the trial, then you're thinking your client might testify, you've got to prepare. There's so much that we can talk about in terms of what goes into that prep. I think to your direct question, it goes back to the earlier point about it may not change much under the existing ethical guidelines, because you're always telling your client you have to tell the truth, and you're always doing what the ABA formal opinion allows you to do, which is what you'd be doing anyway in the trial, right? It's not just unique to the testimony. It's what are the themes of the case, and what are the elements that the government has to prove, and what are the difficult facts, and what do we sort of need to get in to rebut those? That's usually how I think about it for my own purposes. And whether a client really needs to testify, that's the question, not whether they should, but whether they need to. And that's based on what are the elements of the offense, and what's the government's evidence, and what's our argument against, each of those pieces of evidence as it relates to those offenses. And if you can make those arguments based on what's come in through your own cross-examinations, then then I think the instinct is to, protect the client from being subject to cross-examination, and therefore exercising the right not to testify. And then if there's some key point that you really can't get in otherwise, you have to think more carefully about whether you need the client to testify, or whether there's other people who might be able to testify. So in my last trial, that was the analysis. And then there's the more, personal aspect of it, which is like, how will this person do testifying? Are they going to come across well? Yeah, I think there's a thought these days, you hear it amongst a lot of white collar practitioners, that in cases where there are acquittals, it often does come down to the jury wanting to hear from the defendant. And, I think there's two sides of that coin, because clients in a lot of these cases are very sophisticated and intelligent and charismatic and used to being in charge and want to testify. And it can be difficult also for the defense lawyer, we can talk about later, to then prep them for cross themselves, because you don't want to go and undermine your own relationship with your client while you're gearing up for trial. So that could be another touchy subject.
Cassie.
Sure. Yeah, I would say in light of this opinion, you should prepare like you're not having a second chance to do any sort of preparation. And so I think most of us would be doing that anyway. But I think one of the most important things, and Michael sort of teased that, is doing this like good cop, bad cop scenario and role play with your client, so you can actually see how they're going to be under cross-examination. I usually use another person besides myself, because I think it's important to maintain, credibility. I did that when I had important cooperators or even victim witnesses, and I would do that, for a criminal defendant as well. So bring in someone who's going to play the really mean prosecutor and beat them up, so you can see how they are answering the questions, and help them with a lot of those things that, everybody does, like getting upset, taking things personally, or not listening to the question and answering something else, all of the things that can happen, because you're not even going to be able to help them seemingly with, some of the demeanor things. One of the things that came out in the case I had with Michael is there was a cooperating defendant, or cooperating witness testifying, and he kept like looking over at the case agent when he was answering questions. I had a case where this really excellent, super knowledgeable case agent on cross, he was looking up at the ceiling for, at least 20 seconds. And then answering, and he was answering truthfully, and everything was fine. He was just so nervous that he was doing that, and the jury was getting very frustrated. That seems like the type of advice that, like, if your criminal defendant was doing that, can you give them that under this ruling? It seems like probably not, because it seems like that goes to managing testimony potentially. So you want to see that that's the type of thing they're doing, and you may be able to tease that out with more role playing, particularly with someone they don't know coming in and really, like, giving them a hard time before trial. I think that makes that even more important. So you can try to work out some of those things. And also, as Michael said, to assess that in determining whether they really need to testify or not. And then I would say, if you're actually having them on the stand and you need to talk about some of these other things, I think it's important to not only make a record of what the court is allowing and not allowing, but also make a record of what you're talking about with them, so that it's clear that it's counseling, conferring, and not coaching. And so if you're talking about you need to take a plea because things aren't going well, that you're not saying because you're looking up and you answered this question incorrectly and you need to clean up, unless this is fixed. So you have to be very careful and I think documenting it, so you make sure that you're staying on the right side of things.
But it's interesting, you've made the point about sort of performative, which is different than substantive. Is Villarreal really a bar towards precluding counsel from talking about the performative issues? I mean, Michael isn't telling the witness, look, you shouldn't be doing this. You shouldn't be, you shouldn't be answering the questions differently. The performative aspects, are they really barred by Villarreal? I mean, do you think that a defense lawyer, their client's on the stand, a break has been taken, it would be managing testimony to talk about performative, non-substantive, not telling them what to say? What do you think?
I can't really imagine a situation in which you can't have like that general discussion, right? Like, you're at a break and the client's like, how am I doing? I think you have to be able to say, like, well, you're doing great, but you slow down a little, or remember to make eye contact. Probably what you can't do is say, every time they ask you about this, you're making really good eye contact with jury. You should be doing the same thing when they ask you about this. But so much of the cross is hard to predict, because you may not even know, like, if there's multiple prosecutors or multiple defense lawyers, you may not even know who's going to be doing the cross, right? I mean, the point that Cassie left out in that little story about the cooperator was, it was only on cross-examination that he was looking at the agent. He was perfectly fine on direct, but all kidding aside, the point of that is, when you have your own witness up, even if it's your own client, you have all the time in the world to prepare. And so there's a certain degree where the client knows where, okay, now I'm going to ask you about this. And when I ask you about this, make sure that, we cover these points, and then I'll move on. And same with a prosecutor and a cooperator, right? And then when it comes to cross, even as the defense lawyer, you may not know which prosecutor is going to do it. And you can tell yourself all you want, like, oh, prosecutors don't have that much experience with cross, but you don't know how the client's going to do on cross. And I think, the flip side is, there's also all kinds of anecdotes about pivotal prep sessions. I think, like in the O.J. Simpson case, they hired, I think it was Chris Argatis, who's like a legendary defense attorney in the Bay Area, and they hired her to do a mock cross. And that was really pivotal, and O.J. not testifying, which I think he otherwise wanted to do. And so that can sometimes, I think, be helpful, not just for the lawyers as like a mock jury exercise and then refine it, but it can also be very pivotal in being like, okay, maybe it's not a good decision. And that was a thought in a case that I had more recently. It ended up not going to trial, but after the experience where the client testified, that was one of the takeaways, was sort of, how do you prepare the client for cross? Because you can't really do it yourself, right? I mean, you can't get in that mind space to do it. I think you also, if it's effective, it'll interfere with your relationship with the client, while you're preparing for trial. So I think Cassie's point is a good one, which is, having someone else come in and do it and really prep that person independently with maybe if they've never even met before, it gets closer to simulating the experience of being in the courtroom. And I think the government does that often enough. With cooperators, you can bring in a different prosecutor and have them do a mock cross.
Yeah, I mean, the idea of the so-called good cop, bad cop, right? Help you preserve the relationship, but also gives them a taste of what could happen. I guess I want to ask more generally, both of you have done a lot of trials. Um, you know, for those who are watching the program who may not do criminal practice as much as you do, just generally, when you're advising a client, generally, what are the touch points on, client asks, should I testify? Um, how do you weigh that case with the client? How do you advise? You want to make sure you properly advise them. Obviously, that's fact specific. But if there's a general approach, if you guys could share, I think folks would be interested.
I think it's just so different than in a civil case because people want to tell their story and it's hard for somebody who's on trial facing criminal charges to grapple with the notion that like the defense doesn't have the burden. They don't have to put on a case, especially people who are in white collar cases and they're in businesses and they've been in civil litigation, and they've been deposed or maybe they've even testified and they think they're good at it. Or they're just used to being sort of in charge in all areas of their life. There's often a sense, where if the jury hears from me, that'll help. But it's such you're opening the door so dramatically to the cross-examination that it's more, I think, risky than anything else in the view of a good defense attorney. But then how to have that conversation with the client is the challenging one. And I don't think there's ever a right answer because inevitably, if the client testifies and gets convicted, then the defense lawyer might be thinking like, oh, if only they hadn't, if it doesn't go well, you're going to be thinking, oh, if only they hadn't testified. And inevitably, I think if the client wants to testify and then ultimately doesn't and gets convicted, certainly they're going to be feeling like, oh, I should have testified. And I've actually had clients say that at sentencing to the judge. It hasn't gone over well, unfortunately, but the client will say something at sentencing when they have the opportunity to speak to the judge more generally about their life than what led them to this case. They'll say something like, well, and I wish I would have testified at trial because I would have explained, such and such and such and such.
Yeah.
Well, yeah.
Oh, sorry, go ahead.
Well, I was just going to say, we know from experience in criminal trials that if the defendant testifies, it changes the entire arc of the case. And juries tell us that their decision rests entirely on their evaluation of the credibility of the defendant. So it's a big deal. So Cassie, you were about to sort of jump in on this, advising clients on whether to testify.
Yeah, I mean, I think there's a reason it's rare, particularly in like federal prosecutions. When I had a defendant testify, I had a supervisor who basically said, if you did a better investigation, the defendant should not be testifying. I think that's because we found that juries, they even in cases where you see defendants testify and they're very well prepared and they're able to articulate some things. Juries tend to want corroboration, like documents don't lie. And you'll see, especially in like white collar prosecutions, like weaving together through a case agent, all of the various documents and text messages and everything else is a very effective way to keep a defendant off the stand because it's difficult for them to overcome some of that evidence that is documentary and can't really. There are different interpretations, but there's this idea that there isn't. I think that studies have also shown that most people are not very skilled at identifying just from demeanor alone whether someone is truthful or perjuring themselves, and understanding that and talking with the client about that. It's challenging though, because I think particularly in white collar cases, these are folks who are very persuasive to get to where they are. If they're in like political corruption cases, they are people who are used to talking and they think that they are able to, you know, answer questions and weave and adapt in the moment. And so I think that, you know, sometimes that good cop, bad cop thing could be very effective in making folks decide. You know, it's been effective for me as a prosecutor in deciding not to call a witness because I saw that, you know, they really were incapable, even though they were telling the truth, of like doing it in a coherent way. But I think that advising of the risks and giving them a better understanding of, okay, but what's the alternative and what is our strategy, right? How are we going to tell our story through the same documents that they're using? And who are these other witnesses? Usually there are other witnesses or documents or something where you can still get in the themes and story without assuming this really, really big risk. But it's true that juries, like, even though the burden is what it is, you will hear jurors say, like, I really wanted to hear from the defendant. I know that, like, they don't need to, but I would have really liked to hear something besides the attorney just saying it, right? And so I think that being able to try to use the government's evidence, you know, against the government is one effective way to do that. But it is quite difficult because most of, especially white collar defendants, they want to take the stand and want to tell their story. So you have to explain to them alternatively how you're going to do that effectively and why that's a better option.
The other thing that's interesting that you made me think of, Cassie, is like most witnesses in a criminal trial come in and leave. The case agent is allowed to stay in the room throughout. And I think the jury sort of understands that there's a certain degree of bias, like they're a little bit more of an interested party because they worked up the case and they're working with the government. And so, you know, they're pretty good at testifying around that, but that's like a known factor. Most of the other witnesses that the government calls, they just come in for the afternoon and then they leave. They don't really know the rest of the case. The defendant is sitting there with the lawyers and the case agent for the whole trial. And so I think that's part of, you know, juries always get asked during jury selection, you know, you understand the defendant has a right to not testify and you can't hold that against him, et cetera. And some people say, well, I just, you know, the sort of simple, I think if they didn't do it, they would testify. And so those people are struck because they can't, you know, follow the court's instructions. But otherwise, people come in with an open mind. But then the defendant is sitting there sometimes for several weeks. And so there's sort of a natural desire probably on the part of the jury to be more curious about what the person has to say. It's, you know, even if the defendant's not testifying, they're going to be focused on the evidence over the course of the case. There's going to be certain issues that cause them to write notes to their lawyer, et cetera. So that's just a difficult dimension to get around. And then if the client does decide to testify, prepping, there's so many issues that are unique to prepping a defendant to testify, but one of them is that fact that they've been sitting through the trial the whole time. I mean, I suppose in a civil case, if you have, you know, the representative of the business sitting there through the trial, you'll have something similar. And that, I think that can be a good and a bad thing. It's just something that you have to manage. I mean, I think the positive part of that is that you're all in this experience, so to speak, together. And so when a defendant testifies, there's a little bit more of an ability to bring out like an acknowledgement between them and the jury. Like, okay, well, you heard this person a week ago say these things about you. Would you like to respond? And you can connect it to the themes of the case a little bit more than if they hadn't been in the room when that person said those things.
But Cassie, to that point about, you know, the defendant sitting there all the way through trial, case agent sitting there all the way through trial, jurors hear from the case agent, they don't necessarily hear from the defendant. You know, how does that strike you? And now that you're on the defense side, how does that affect how you plan for trial and advise the client?
Yeah, I mean, I think that my view is that it's usually better to put on some case on the defense side, because I think that jurors, they're kind of like waiting, and especially as trials get longer and they're going on and on, they're like, okay, great, what are we going to see from the other side? And you don't have to. But I have found it, and the cases that made me most nervous is where they did put on some sort of case, and the government doesn't have notice of a lot of like who that will be. I had this case where there were like it was a small like threat to kill a federal officer case, and the other side called like 10 witnesses, and I had no idea who they were. I ran outside with the case agent on a break to ask them like, why are you here? What are you talking about? And so, and I thought they did a really good job of like raising some issues that I hadn't really thought of. I mean, I thought if anything, they were going to have the defendant testify, but they had, various people who I thought made some interesting points. And so I do think that the jury then feels like they at least have a counter story instead of just poking holes. I think there are ways to bring in your counter story through the government's witnesses. And I think that can be very effective, but nothing really beats having like a case, someone who's tying together the evidence. And so trying to figure out how you can do that, maybe with a few witnesses, or you're just going to have to rely on a really good closing when you're doing that. Because I think the jury does want to understand like, okay, well, if it's not this story with all of this evidence weaved together that, case agents can kind of put a bow on, how am I supposed to interpret it? And that can be hard. That's a big, heavy lift to do all in a closing. So if you have at least a few witnesses you can call to try to, be tied to some of those key documents where there's an alternative explanation, I think that can be really helpful.
As a prosecutor, did you ever have any luck getting the court to grant reciprocal discovery or to the defense to turn things over before you were in mid-trial? And how did that play out in cases in our district?
So there were some judges who would allow it. I would always ask for it and then make a record that I asked for it. Some judges would require it. And then there would be oftentimes motions, particularly from the public defenders that said, look, this is actually getting into strategy, so we don't want to disclose it until we're like in trial. And most judges agreed with that. There were some judges who required like more reciprocal discovery. Judge Walter, in the case that we had with Michael, it was like this very lengthy exhibit list process where the government, I think we were disclosing our exhibits like 3 months before trial. So there were generally not a lot of surprises there, but he did allow for some of like, if you do have something that you're bringing up that came up directly in response to something in trial, you obviously can do that. Other judges would say no, like you can get it as the person's going up on the stand. If you need more time to review it, you can go ahead and do that. And so, you just have to be adaptable in those circumstances. And I think that, on the side of, crossing someone, I think that adaptability is one of the most important things. And I know that, now I'm doing civil practice. I had my first arbitration where I crossed someone, and it's a very different ballgame where you have, oftentimes in criminal cases, we don't have any transcripts. We don't have any statements from the defendant or just like a very short one. We have documents and evidence, whereas in civil, you have maybe multiple depositions. In my case, there were 6 depositions from all of these different matters. And there can be an inclination to just do this very scripted cross-examination that's identifying potentially every little tiny inconsistency. I don't think like days and days of that is particularly useful. And I think that that overly scripted kind of thing can be a little boring for the jury. I think it's good to have like very clean lies about important things if you have them, and then adapt in the moment to the testimony. So you really need to do more active listening instead of just this like lengthy scripted thing that just has all of the deposition testimony that can be effective for some like very important salient points. But I think that the jury kind of gets bored, or the arbitrator will get bored when it's like every little inconsistency, some of which don't really matter or aren't really material to the case.
Yeah, that's the, you've got this big record and you just boil the ocean on every issue, every statement, and you create a 650-page outline. And then you get in there and, we sometimes will make the mistake if you don't look up. You have to listen to what's going on, and don't be so wed to the outline. It's interesting, Cassie, your observation about the difference between civil and criminal practice around prepping for a cross-examination. Michael, what's been your experience? You've done arbitrations. How do you compare and contrast the challenges and opportunities in prep between civil and criminal?
Yeah, I agree with Cassie's point about there's just a lot more like of a rigid sense of being tied to prior statements when it comes to cross-examination in civil cases, in my experience, which I don't really, I sort of bring my criminal trial background even to my civil cases. And so I've never quite understood the approach of just sort of like impeach the witness on everything they've ever said. And you see that start to filter down even to like the pre-trial phase in depositions, where the deposition becomes just sort of like the first half of some outline of gotcha, where they're just, the other side just needs to get a certain amount of admissions out of the deponent to then wield against them later at trial. I just think I don't think it's as like sharp and precise as the type of cross-examination that you have to deal with in a criminal case, because you don't really know what the person's going to say. Which, going back to an earlier point though that Cassie was talking about, I think if I remember correctly, Judge Walter in our case did have like similarly strict requirements on the defense. So the issue is challenging from a perspective, like in a civil case, both sides have the same obligations, discovery wise and trial prep wise. In a criminal case, it's just so different because of the defendant. It's centered around the defendant's constitutional right to testify. So when you have a judge saying that you do need to disclose who your witnesses are going to be, then you have to basically say, well, who might we call? Some of that gets into strategy. You may not call any of them because you may only be calling them to corroborate any testimony that the defendant might provide. And you don't know if the defendant's going to testify, until that moment comes. And so I don't necessarily know that it's a fair obligation to put on the defense side. To be fair, even when judges do it, it's a gentler obligation than on the government. But it sort of complicates things from a trial perspective, because in a civil case, you can sort of map out both sides of the case. And in a criminal case, the government certainly maps out its case. But then when the judge says to the defense, you're going to be putting on a case, you don't want to be flippant about it. But the answer is usually like, I'll let you know when the government rests. I don't know. We don't know. You obviously have to prepare, but I think a lot of that centers around the issue of the defendant testifying. Because to Cassie's point, like the jury does want to see a case. So you may be thinking, well, maybe we can call, 5 people who knew the person or worked with the person. But then the government, if that has to be disclosed ahead of time, the government may then raise an objection that this is just, impermissible character evidence. And then you have to have like a showing of proof, an offer of proof. What are these people going to say? But that gets into the defense strategy. But certainly, like going back to that sort of mental checklist that I had at the outset of like, what do I need in and to argue at closing? And is there stuff missing that I haven't been able to get in on cross of the government's witnesses? Then the question before, do I need the client to testify, is like, could the client's wife testify, or could the client's business partner testify? Are there other ways of getting this in? Because I do think, Vince, to your point, like as much as you may try to script the defendant's testimony, and I don't mean script in terms of what they say, but I mean in terms of topics being covered, it's very dangerous to think that you can just have a client testify on one narrow issue without opening the door to, the government running wild. That's
Right.
a very difficult tension.
Credibility is never a collateral issue, right? So once they're up there, it can open the door to a lot of things. And also on that disclosure, Michael, one strategy is to, tell the government you have 10 witnesses, send them running around and going over and talking to all of the witnesses instead of preparing their closing statement, their closing argument, and then not call any. So, that can also be, it's not always super helpful for the government either when judges require this because a lot of times it creates like a lot of work right in the middle of trial when you should be doing other things. And you kind of have an obligation to go and try to talk to all of these people, figure out what they're going to say, interview them, prepare crosses for them. And in most cases, I think it would be sort of an over disclosure. And then they don't end up getting called, or it's maybe like one of them. So.
We've got a couple of questions in the chat, so I'll read them out. One of them, these both relate to conferral, non-conferrals. One of the questions was whether non-conferral requests apply in civil cases. Have we ever seen those in civil cases? Do either of you have a reaction to that? Have seen it?
I would assume they do, because it's really the identity of the person as a witness. And if anything, in criminal, there were more protections, which is why you had those earlier cases saying, it's not okay to completely bar attorney-client communications overnight, like in Geeters. So I would think that they do if requested, because that truth-seeking function is still applicable.
Yeah, and I think you hear it so much more in civil cases. Like, did you speak to anyone at the break, right? Because if the person's not your client, then there's nothing privileged about it. But it's a little bit like seeing the jury in the hallway. I had a bench trial a couple of weeks ago, and my client is a business person, and it's a little bit awkward because, especially in a bench trial, like the jury's not in the room, the judge can ask questions, you're all sort of in it together, and I met the client for breakfast, and we finished prepping, and then we started the trial. And then you break for lunch, and you're sort of just like, I don't want to be rude, but there's not much I can talk to you about for the next hour. It's a little bit strange, but I think that's the same sort of the ethical opinion certainly applies to both situations.
Yeah,
and I think it's more likely that it would come out and be an issue to the extent that someone wasn't following those rules in a civil case.
Yeah.
Right.
There's definitely not much that's civil about civil litigation, right? Ironically, criminal practice in that regard somewhat better. There was another question here. A question is, do you suggest that the attorney ask for guidance under seal so the prosecutor does not know what the problems with the already given testimony are?
Yes, I would think that is what I would recommend, and what I would try to do myself. If I were in that situation.
The problem with that, though, is that the defense lawyer's privilege obligations to the client also pertain to the judge. So there's often this notion of like, oh, well, there's an issue, so let's just raise it in camera. But you can't raise privilege. You can't disclose privilege in camera either. And this often comes up in other contexts in criminal practice, like seeking a subpoena. You have to articulate some theory of relevance that's some theory of the defense. You certainly don't want the prosecution to know. But if it's, you might not want the judge to know either. And in a criminal case, if the witness is testifying and the witness is the defendant, unfortunately, the odds are in most criminal cases that they end in a conviction. And then this is going to be the same judge who's imposing sentence, which is a general risk of the client testifying. Not only that the jury doesn't credit it, but the judge doesn't either, even more so than having sat through the evidence, and then it can be very painful at sentencing. So I wouldn't feel it's appropriate to raise a concern like that with the judge only, putting aside the prosecution.
Yeah. So we only have about 2 minutes left. So I wanted to get any last words from either one of you, or hopefully both of you, on the question of, trial prep, prepping for cross-examination, any lessons learned from your trials for those that are listening. Last word, Cassie, Michael?
Sure. I think that, the most prepared attorney is often has the advantage here, right? So knowing all of the documents, knowing your own record, that's how you're good at adapting in the moment. And, if you're crossing someone or in preparing your client in advance, it's knowing everything as deeply as possible. And I think the difficulty with, adapting is that you don't know some of the records, and you don't know some of what is in evidence. So you can't take advantage of, someone saying something on the stand because you don't know where it is. You may know it exists, but you can't find it in the moment. So I would say prepare, prepare, prepare.
Michael?
Yeah, related to that, I think that's sort of like a micro point about like a good cross in the moment. And I think sort of like anything in this practice, the only way to really get better at it is to do it a lot. My experience as a prosecutor was you get very good at direct exams and you don't get much experience for cross. And then since trying a number of criminal cases in the last 5 years, I've done a lot of cross exams, and I feel like that strength is caught up. But I haven't done many directs in a criminal case. And so just sort of a humorous anecdote to end on. When that client testified in my last criminal trial, it was in part because there was some very important evidence that I needed to get in. And there'd been a lot of pretrial litigation about it, and there was a fight over it. And so he was on direct. And in addition to all the, important points that I wanted to convey about his demeanor and personality, I really needed to get this evidence in. So I had a whole outline, and I was back in the mode of a direct that I hadn't done in a number of years. And I was nervous, and I had it all mapped out, and I got to it. And I was, I was pretty much ready to admit it. And so I have my client on the stand, and in front of the jury, I said, "Your Honor, the government moves to admit exhibit." Oh my God. So there's muscle memory to it.
That's right. That's right.
I hadn't done a direct since I've been a prosecutor.
That's right.
So I think that's the parting lesson for today is remember if you're representing the defendant or the government, and if you're on cross or direct.
Remember which side you're on. Yeah. Well, thank you both on behalf of BHBA. Thanks to you both. You have brought amazing insights to the program. For those that are interested, we'll circulate their bios and their information to reach out. Also, a special thank you to Sandrine Maglori, who's a student at Loyola Law School who helped us prep for this. And we will be back in touch and look for more programming from the criminal law section soon. Thank you.